Mr. Wall.
My lady, our first witness this morning is Professor Albert Sanchez-Graels. Could the witness please be sworn or affirmed?
Repeat after me, please. I do solemnly,
sincerely and truly,
declare and affirm that the evidence I shall give shall be the truth, the whole truth, and nothing but the truth. Thank you, please.
Professor, could you start your evidence by stating your full name, please?
My name is Albert Sanchez-Graels.
Thank you. Professor, you have produced, and we are grateful for it, a very comprehensive report. It's inquiry document 000539153, to which we'll be referring on a number of occasions in the course of your evidence today. Can I confirm that it's your own work, that you are aware of your obligations as an independent witness, and that you've signed it, and that it's true to the best of your knowledge and belief?
Yes, that's correct.
Yeah. Thank you for that. By way of brief introduction, Professor, you were asked, were you not, to provide an expert report on the key principles, important legal frameworks and relevant guidance with respect to public procurement by the UK government and devolved administrations, and how this may be improved in the future.
That's correct.
Yeah. In terms of your own background, you are a professor of economic law at the University of Bristol.
Yes.
Law School, is that right?
That's correct.
You have previously held numerous academic posts. You have a European doctorate in law on your thesis, The Interaction Between Procurement and Competition Law.
That's correct.
And your particular research and expertise interests concentrate on the way in which the public sector interacts with the market and how it organises the delivery of public services, especially healthcare.
Yes.
And at risk of embarrassing you, Professor, you are globally recognised as a leading scholar in the regulation and governance of public procurement. Is that correct?
I think that's correct.
All right. You have to your name many publications, including ones specific to procurement and COVID-19, which are listed in your report. I won't go to those now. You were asked in relation to your expert evidence to split it into three temporal sections. First, prior to the pandemic, or prior to the 1st of January 2020, is that right?
That's correct.
Second, between the 1st of January 2020 and the 28th of June 2022.
Yes.
And then third and finally, after the pandemic, as defined as being after the 29th of June 2022 and onwards.
Yes.
Yeah. All right. I want to ask you then, in relation to the temporal scope of your evidence, and to the extent that it's relevant, Brexit, which falls within that initial period, could you offer a summary of the evidence that you've given in your report, please?
Yes. So I think it's important to contextualize the timing in which the procurement for the pandemic took place, which overlapped for the first year with the transitioning out of membership of the EU. But despite the fact that the UK left the EU and then was in a transition period and eventually fully left, the rules were consistent throughout the period. And also despite the fact that the government at the time had quite vociferously complained about the EU procurement rules and promised a bonfire of procurement law, that change didn't take place. And actually, the process of review of the EU-derived rules only was completed last week when the Procurement Act came into force. So for the purpose of the report, the rules were constant throughout those three periods that you have mentioned before, during, and after the pandemic.
Well, we'll come back to the enactment of the new legislation, as you rightly point out, only as recently as last week, in due course. But before we move on from this topic, there was a joint procurement agreement, or the possibility of a joint procurement agreement, a matter upon which you touch in your report. Could you offer your evidence to the inquiry in relation to that, please?
Yes. So while the UK was transitioning out of the European Union was starting to put together its own collaborative approach to the procurement of supplies such as PPE or ventilators. And there was an opportunity for the UK to join this joint procurement, which, in my view, the UK unilaterally decided not to take. I also explore in the report how the reasons given for not joining are, in my view, not particularly convincing, because even if it was true that specific officials of the UK government were not reached because the email addresses were wrongly used by the European Commission, that didn't mean the UK government was not aware of those efforts and they could not have chased the opportunity of participating. It was also clear, in my view, that the opportunity to participate was open throughout the period, regardless of Brexit. And I think it's also clear that at the time, that was seen as a strangely missed opportunity for the UK government to access another route to the supplies.
Well, that's what I wanted to ask you. No matter the reasons for non-involvement, what was the effect of non-involvement?
So the effect of non-involvement is that the UK was outside of that collaborative effort that was trying to source PPE in a flexible way through the creation of so-called framework agreements. So they were not definite commitment, but was sort of standby opportunities to draw from those framework commitments. And that forced the UK to put all of the mitigations and all of the routes to market that it thought it needed on its own in place. So I think that, in my view, exacerbated the risk of buying too much, because the UK was going it alone and was not doing it in a flexible way like the European model was doing.
You consider that it placed the United Kingdom at a competitive disadvantage in procurement terms?
I think so. I think it just didn't take up an opportunity of having more options to source the materials that it required.
Could I ask you to slow down, Professor? We have a stenographer who's trying to take a note. I'm sorry, if you have a fast way of speaking, as I do, it's difficult to change, but if you could just slow down.
Of course, apologies, my lady.
Can I just ask you to play devil's advocate for 1 minute?
Yes.
So you say that it exacerbated the risk and we should have participated. What are the arguments against participation?
So the arguments against participation mainly have been that after the fact, the initial efforts from the European Commission were not particularly helpful, and, for example, PPE had to be rerun. But I think...
Sorry, PPE had to be?
Had to be rerun. So the first call to market was not successful, and they had to stop it and then go again to the PPE market. And so there's the view that it wouldn't have made a material difference at the time. But I think that's not relevant, because the question was, at the point of deciding whether to join or not, what was a possible downside, and this would not have committed the UK to actually buy anything under the European framework. It would just have been an additional opportunity to access markets in a different way.
All right, thank you. Can I move you on to public procurement? What is it? If you'd like to say a few words on that.
Yes, so I think in simple terms, public procurement is a set of rules and policies that try to constrain and guide how the state buys things or services from the market. And procurement rules have fundamentally two purposes. One is to ensure the integrity or the probity of the process, because it involves very large amounts of money and opportunities. So we want to make sure that access to those opportunities is on a level playing field and that there's no favoritism or corruption of any way. And it also tries to foster value for money. So it tries to ensure that the contracts that we put in place are such that we obtain value because we are spending taxpayers' money. So procurement rules have these two considerations of preventing corruption and preventing maladministration. And procurement looks a little bit different in different countries, but there are very clear international standards, and we also have very clear international frameworks. So fundamentally, the rules are about the process. We try to regulate what transparency we need to give to opportunities, what times we need to follow, what sort of objective criteria are permissible or impermissible, and we try to create a harmonization of this procedure. Procurement rules are not about what needs to be bought or for what purpose. Those are issues for policy. And in each country, the policy looks a little bit different.
All right. Do remain mindful of the
Apologies.
Requirement to keep the pace down, if you wouldn't mind.
Yes.
You say that very large sums of money are involved. Do you know, in broad terms, what the annual spend is for the United Kingdom?
So for the United Kingdom, the estimate is in excess of £300 billion.
All right. And sorry, please.
That represents about a third of the public sector budget, in simple terms.
And what proportion of that is devoted to healthcare?
So the numbers are not always easy to track, but healthcare is the biggest non-defense spend in any jurisdiction, and certainly in the UK.
Non-defense spend?
Non-defense spend. So defense probably accumulates also very large amounts. If you're interested in the details, I can...
No, I think because the detail is contained within the report, it's sufficient, I think, for these purposes, for you to provide the summary that you are. Let's move on to the aims of public procurement regulation, if we may.
So, as I was saying, the main aims of public procurement regulation are to ensure that there is integrity and good administration in the expenditure of public funds. And those aims fundamentally try to be facilitated through mechanisms of transparency. And that's the short of it. So procurement regulation tries to ensure that the expenditure of public funds is transparent, is accountable, so that we prevent corruption and we ensure value for money to the maximum possible extent.
Are there different ways of achieving that or different choices to be made?
There are different choices because procurement systems could be put on a spectrum. You could have very rigid procurement systems that create sort of very easy to follow step-by-step rules, but those are seen as maybe stifling commercial acumen or the possibility of doing things in a creative way. At the other end, you could have very flexible procurement regimes that could be quite complicated and give lots of discretion to the specific officials, but those are seen as creating more difficulties, in particular in controlling the exercise of discretion. So there's this spectrum of rigidity versus discretion-based, and each country makes its own choices. Now, there are trade-offs in both of them. I think if we are really worried about corruption, we want to tend towards rigidity, because then we can control each process and each part of the process. If we are more worried about value for money, we probably want to create more flexibility and more discretion. Now, the other trade-off is on the complexity of the system and the underlying infrastructure of we want to run the system. The more rigid the system, the less demanding it is on the procurement workforce. The more flexible and discretion-based, the more it requires a highly skilled procurement workforce that will be able to exercise that judgment carefully. So those are the choices that need to be made. And then there's also choices about the level of challenge of procurement decisions that is allowed. So if you want to have a very open and accountable system, probably you want to be quite generous in standing, for example, on the opportunities to challenge. If you want to have a very effective procurement system, you probably want to limit challenge. So that's also another sort of spectrum where the systems move.
Are you able to comment on where the UK sits within this spectrum and that balance between rigidity and discretion compared to other countries?
So I think that the UK sits towards the discretion end of the spectrum because there are many enablers for contracting authorities to do things in their own way. Even in the regime that applied during the pandemic, it's possible to carry out negotiations or to carry out competitive dialogues with a very low threshold of justification. So it's not a very strict system where, for example, you would say, if you want to engage in negotiations, you necessarily have to negotiate with 3 or with 5. In the UK, each contracting authority can come up to its own view of how many economic operators to engage with. And it's also flexible in that there are no hard constraints on what could be considered, for example, in terms of award criteria. So each contracting authority decides its own mix of technical and price, and within technical, what to look at. So I think it tends towards the discretion-based end of the spectrum.
All right, that takes us, I think, on to the basics of public procurement regulation. Would you say a few words about that topic, remembering to keep the pace a little bit down?
Yes. So I think, like I said, procurement regulation looks a bit different in each jurisdiction, but there is a broad consensus on the main principles of procurement regulation. And those principles, in my view, include the predictability of the system. They include the effectiveness of the system. And by effectiveness, I mean that, first and foremost, procurement is a tool for the public sector to obtain the goods or the services that it requires. So the main thing it has to do is deliver on that front. But of course, it has to do it in a way that ensures the economy or value for money. It's not about buying things at any price. It's about having a good balance between what's required and the outlay that it requires. It's also important for it to be transparent, and that transparency has to do both with what is disclosed to the public through proactive publications, but also with adequate record keeping. So it's a principle that every decision has to be traceable, and there has to be a record so that can be scrutinized, and transparency is an enabler for accountability. It's also very clear that procurement has to ensure integrity, and that will require preventing corruption, preventing conflicts of interest, and preventing collusion, which are three different ways in which the procedure could be tilted or not lead to a level playing field. And I can expand on any of those if they are of interest.
Well, what I'd like to ask you is that these principles, or these regulatory principles, are they applicable both in business as usual or normal forms of procurement, as well as in emergency situations, to which we will turn in a few moments?
So the key principles are applicable throughout. What's going to happen is that in emergencies, the balance between the principles might shift. So it's well understood that, for example, effectiveness and value for money may not always be maximized. There will be times, and I'm sure we will come to it, where the market is such that probably you cannot get things at the price you would want, and you still need to get the things. So you need to facilitate effectiveness over value for money, but that doesn't mean value for money goes completely out of the window. The way that I phrased it in the report is that in normal times, value for money is about maximizing the value for the taxpayers' funds. In my view, in emergency times, value for money is about minimizing the excessive prices that are being paid, minimizing the risk of waste of taxpayers' funds. So what these principles look like, or the way they are implemented, may shift, but the principles apply throughout.
Is that true for all of the principles? Are there any that would apply in any event, whether it's emergency procurement or business as usual procurement?
So the ones that apply in an event have to be transparency for sure, and they have to be accountability for sure. Those two, basically, without them, you cannot achieve even the anti-corruption goal of procurement rules. So those definitely have to apply.
And do they apply in the same way in emergency procurement or in a different way?
They apply in a different way because there's also an implicit principle of proportionality. So what would be disproportionate would be, for example, in an emergency to require long lead times and to ensure that transparency is out there for everyone to look at before things happen, because it can be that transparency has to come after the fact when you're really rushing to market, but transparency has to be there. And I think what is important to recognize in emergency situations is that while things can be done in a different way by shortening processes or dispensing with some phases, the fundamentals remain the same.
All right, let's move on. I think we'll come back to those when we reach the specifics of emergency procurement in a few moments. Before that, I just want to ask you about thresholds or the scope and modes of application of public procurement regulation. Would you provide the inquiry with your reflections on that topic, please?
Yes, so we said procurement rules apply whenever the public sector buys something, but they don't apply to any part of the public sector buying anything for any value. They are tiered to ensure that proportionality that we're talking about. So procurement rules will apply to most of the entities in the public sector. And for the purpose of the report, all COVID-related procurement was covered because it was carried out either by central governments or by the central government of a devolved administration or by a hospital which is funded by a public authority.
When you say tiered, you mean by spend?
By spend is the main way of making obligations proportionate. So the procurement rules establish different value thresholds above which full compliance is required.
What's the value threshold for central government?
So the value threshold for central government is about £140,000 for goods and services, and for regional and local government, but that would not cover devolved administration because devolved administration is central government for these purposes.
Right.
At regional and local government, it would be about £215,000 at the time.
So it's a higher threshold.
It's a relatively high threshold because it requires compliance, for example, with international advertising of opportunities. It requires compliance with the periods of time that we will discuss later. So below those thresholds, it's understood that it would be disproportionate to impose full compliance with those requirements.
Finally, on this topic, how is oversight achieved in relation to this?
So oversight is achieved in two ways. There are in each system a mechanism of oversight through audit-based mechanisms, and in the UK it's well known that it's done for the English jurisdiction by the NAO and in its devolved administration by the equivalent audit offices. And then there is the possibility of judicial review and different remedies under the procurement rules to challenge procurement decisions. So the way I understand it is that oversight more in the public interest is carried out as a matter of course through these audit-based mechanisms, and challenges based more on the private interest of those tendering for contracts is carried out down the judicial route. But there are different models, and the observation that I make in the report, and it will be important later, is that the mechanisms of oversight, but particularly of challenge in the UK, have not been as robust as would be desirable. And that's one weakness of the system throughout the period covered by the report.
Well, we'll come on to a couple of those legal challenges in due course, both of them brought by the Good Law Project. Before that, I'd just like to understand from you the timeframes that we can assume occur in business as usual procurement exercises.
So in business as usual procurement, contracting authorities have an obligation to advertise for a relatively long period of time, and it depends on whether they are running single-stage or two-stage procedures. So if they are engaging in single-stage procedures, so what would be called the open procedure, they would have to advertise for about, adding the standstill period, 35 days. And if they are in two-stage procedures, that goes longer. But that's the minimum legal requirement. In any case, in practice, what the statistics show is that it can take more months for the completion of a procurement exercise. I think the average is in excess of 90 days. Of course, there will be quicker and longer periods involved in those statistics.
In a previous module, Module 3, Sir Christopher Wormold was asked about the procurement of gowns. And in that case, he said that a period of, I think it was either 9 or 11 months was quite normal. Is that your experience?
So I think what we need to distinguish is what would be a one-off procurement and what are called commercial vehicles for procurement. So I think that's quite important to bring in. So if a contracting authority tries to buy of its own from scratch anything, be it gowns or any other material, they have to run through the process of designing it, advertising it, running the competition, awarding. 9 months doesn't seem out of the norm. But that's not the only or even the quicker way that they usually can do that. There are specialized central purchasing bodies that create what are called framework agreements or dynamic purchasing systems, which are ready-made route to market or commercial vehicles. That means that they do the design and the advertising and the evaluation and a preliminary award or a preliminary inclusion in the dynamic purchasing system, so that when a contracting authority, say an NHS trust, wants to buy gowns, they can simply look at what framework or dynamic purchasing system has been put in place by NHS supply chain, for example, or the Crown Commercial Service if they're buying something else, and simply run a mini competition, which is much quicker, and it could be a matter of a couple of weeks. So I think that it's not untrue that it can take 9 to 10 months to buy gowns, but I think it's also true at the same time that if the right framework is in place, it could take just certainly under a month, maybe a couple of weeks.
So I wanted to ask you, what are the other methods of accelerating procurement, short of direct awards, to which we'll turn in a moment?
So the procurement rules already have embedded the understanding that things cannot always go according to the ideal plan. So when a contracting authority faces an urgent requirement, not an extremely urgent one, but an urgent one, they can engage in what's called accelerated procurement, which means that they can significantly shorten the period of time that will be required to advertise and to award contracts. And that in short, cuts it to half the length of the period in ordinary times. And if you're interested in the detail, I can also give it to you. I think it's reflected in Table 3 of my report.
Is this where you set out the time periods?
Yes.
For the different...
So in that Table 3, which is page 27, the time periods show that when the requirement is urgent, the advertising goes down to a total of 25 days for open procedures or 35 days.
I want to pause for a moment and we'll see if we can get that up on the screen. It's INQ 000R. You've beaten me to it. So this is, we have now the table that you're speaking to.
Yes.
Can you see that, Professor?
Yes.
Do you want to, I'm sorry to ask you to do this, but do you want to just go back to what you were saying and say it again by reference to this table?
Yes. So in this table, the standard times for ordinary procurement are displayed on the first row, which talks about the default time scale, and those are the 45 days for an open procedure or 70 days for a restricted procedure. If you use an electronic procurement platform, which is the usual way of doing things these days, it gets reduced by 5 days, so it's 40 or 65 days, and that would have led to those basically 3 months in practice of a standard procurement exercise. But if the need is urgent and it would not be possible to comply with those more extended timelines, then it's possible to cut it down basically by half. And if it's a one-shot open procedure, the advertising will have to be open for 25 days. If it was a two-stage procedure, then it's a 10 plus 15 plus 10 days, so it's 35 days for a restricted procedure or a competitive procedure with negotiations.
So this deals with urgent and extremely urgent procurement.
But that's different. So the difference between urgent and extremely urgent is that urgency is a low threshold to cross. It's simply the contracting authority realizes it needs something quickly, and it can simply shorten. It's not strictly a matter of convenience, but it doesn't have to provide very detailed reasons why they're doing things in an accelerated way. But when things are extremely urgent, and this is a defined test, this has to be something that a diligent contracting authority couldn't have foreseen, that it's beyond its control, it didn't do anything to contribute to that extreme urgency, and it would not be possible to even comply with those shortened timelines. In that case, that's when we open the possibility of what you refer to as direct awards, and those can take place without any minimum time period. So it could be a matter of hours.
There's no doubt, is there, Professor, that the pandemic itself was an example of where Regulation 32 direct awards or extreme urgency did apply?
There's no question. But there's also no question that it didn't apply throughout the pandemic in the same way, and it didn't necessarily apply to any type of procurement. You still had to comply with the specific requirements for the award of each specific contract.
And does that, so just to unpack what you've just said, it's not possible, at least under the old regime, pre the Act that came in last week, to issue a blanket Regulation 32 treatment of all types of procurement. Is that right? Each individual act of procurement must be justified by reference to Regulation 32.
That's correct.
We're going to come on to it, but since it's arisen now, is that position changed under the new legislation?
So the position has changed under the new legislation in that under Section 42 of the Procurement Act 2023, it is possible for a minister by regulations to authorize on that blanket approach for a specified period of time the resort to direct awards without having to engage in a award by award analysis of whether the rules for extremely urgent procurement apply or not.
All right. I just want to understand also from you, you've made it clear that the circumstances of the pandemic were such that it was clear that Regulation 32 would apply, albeit on a case-by-case basis. How rare is the use of Regulation 32 more generally?
More generally, it's very rare. And I think that is borne out by the statistics. I mean, there's no great quality procurement data, and I'm sure we'll come back to that. But before the pandemic, it was extremely rare. You could almost count them with the fingers of one hand in any given year, how many times you would have an extremely urgent procurement. And I think that's probably for two reasons why. And one is the test is very stringent. So this need to demonstrate a genuinely unforeseeable situation is a high threshold to cross. But the second one is that there are loads of frameworks in place. So when some contracting authority needs something really, really quickly, they could probably find a framework they could draw from.
All right. Could you tell us a little about the risks inherent in emergency or very urgent procurement and how to mitigate them?
So the main risk in extremely urgent procurement is that things are done at speed and there's no significant planning. There's also no significant engagement with the market. It's a matter of a contracting authority finding someone that can provide what's required in the very short term. So there's, of course, a challenge from a value for money perspective in how things are done. Competition is deactivated, so we cannot trust that the conditions given by whoever is approached are going to be reflective of the market. And also, whoever is approached knows that the contracting authority has an urgency and therefore probably a higher risk appetite, to put it in those terms. But the second challenge is that it's a free choice of who to approach, and therefore corruption becomes a significant issue to consider, because in having that free choice and only having to provide transparency after the fact, it could be that the contracting authority is guided by considerations that are not permissible in other times.
It may be obvious, but just to put the matter beyond any doubt, where one is not engaging in direct awards, how is that risk of corruption or abuse minimized?
So when one does not engage in direct awards, the first thing a contracting authority has to do is publish a contract notice, which basically indicates they have an intention to award a contract. They have to describe what that contract looks like, and they will have a call for competition of different sorts. And that will allow the market to be warned about what's going to happen and to look at those decisions. For example, they could challenge the specific procedure that wants to be used, or they can challenge specific requirements if they think that that steers the contract in favor of specific potential providers. That's one way of trying to minimize the risks of corruption. The other one is, of course, that contract is going to be a matter of record. So looking at oversight, it could be that the contract is going to be picked up later, and knowing that somebody could look into it is also a good deterrent for corruption. Whereas when one is engaging in direct awards, there's no transparency before the contract is awarded. And as we will see later, there's also no guaranteed transparency once the contract is awarded. So that contract can live in some sort of vacuum and in that way be shielded from oversight or from challenge. And that breeds risks of corruption. And that's why we have rules to try to minimize that.
What about contingency arrangements in the UK, and to the extent that you're able to comment abroad, to address or mitigate these risks in advance? Was any of that done?
So some of that was done, both in the UK and in other places, through what's called maybe just-in-time contracts or through these more broadly framework agreements. I think that the international guidance is clear that you should try to avoid finding yourself in a position where you're going to be extremely urgently awarding contracts. And that's why you want to have either contracts with a standby clause or with some sort of suspensory condition, or you want to have framework agreements that you could draw from at the time of need. And this is, for example, how emergency response agencies operate. They know they will have to deal with some emergency somewhere, sometime, and they're not going to wait for that emergency to come up to put the contractual mechanisms in place. They have predefined suppliers with pre-agreed terms for those supplies or works that they would require.
Thank you, Professor. Let's move on, if we may, to public procurement legislation and guidance within the UK. Your report sets out the provisions that apply across the devolved administrations so far as primary legislation is concerned, and you deal also with secondary legislation and so-called PPNs. Does the effect of that legislation differ to any great degree across the devolved administrations?
So up until last week, so in the regime applicable during the pandemic, there was no significant difference from a substantive perspective across the 4 nations. In the UK, there were at the time 2 fundamentally distinct sets of legislation, one for England, Wales, and Northern Ireland, another one for Scotland. There were 2 separate transpositions of the European directives, but they were fundamentally equivalent. And in the report, I have highlighted where there's different wording, but that's the exception. Most provisions are exactly worded, and they are also very closely tracking the European directive.
What about competitive procurement in UK law and policy?
So what's clear under the regime is that the starting point is procurement has to be competitive, and contracting authorities will have a choice of different procedures. They had a free choice between open, one-shot procurement or restricted procurement, which was a 2-stage process whereby any company could express interest in participating in the second stage, and then through shortlisting, some would be invited to that. And that's how we expect procurement to be carried out. But at the same time, as I said before, there was flexibility in that when the grounds in Regulation 26 were met, it was possible to engage in other more flexible procedures, fundamentally allowing for negotiations or allowing for competitive technical dialogue. And what a contracting authority had to do in those ordinary times is choose the procedure that was more suited to the specific need. So if they were buying something very complicated and very innovative, they probably wanted to go down the route of, say, a competitive dialogue or an innovation partnership. If they were buying something extremely commoditized, they probably wanted to use an open or restricted procedure. But also, as I said, and this is a matter of concern for other reasons, but there's also been an increase in the use of these frameworks and commercial agreements. It's been seen that contracting authorities don't all have to be running an open procedure for photocopier paper, and that's why we've had lots of centralization for ordinary times when Crown Commercial Service or in the healthcare sector, NHS supply chain, have put together these framework agreements that fundamentally do 90% of the procurement, and all the contracting authority has to do in ordinary times is call off from them through a mini competition in the terms of those frameworks.
And do we observe that centralisation within devolved administrations as well?
Yes, that also happens in the devolved administrations. I think that the 2-tier centralisation for the general public sector and the healthcare sector that we see in England is also replicated in the other devolved nations.
Now, there then follows within your report quite a detailed section on the legal and policy framework, focusing on evolving guidance. I'd ask for summary box 16 in INQ 000539153. It's page 72, to be displayed, and then ask you to comment on it. It spans 2 pages, so if we'll start with the first, that would be very helpful. Would you share your reflections, your comments on this topic, legal and policy framework?
Yes. So the UK approach to creating the legal framework has been to create legal requirements very sparse or very minimum, and to develop significant additional requirements through policy. That policy usually is encapsulated in procurement policy notes, and those procurement policy notes address lots of different issues from net zero, social value, and other aspects. At the time of the pandemic, in the run-up to the pandemic, there was no guidance on emergency procurement because this was a rare event, and also because whenever rare emergency procurement happened, it was in a very discrete and contained setting. So the first thing that the UK government did, but also the European Commission did, and then the Scottish government also replicated, is to issue guidance on how to approach emergency procurement at an unprecedented scale. And that's what I have termed here as sort of a first wave of guidance in March and April 2020. And what this guidance did is clarify that case-by-case analysis that we refer to for the use of extremely urgent procurement didn't have to be a very cumbersome exercise, because it was recognized that the pandemic allowed resort to direct awards. And both the UK and the European Union guidance then reminded public buyers of the requirements that still remain. So even if you could, without having to wait for any specific period of time, directly award contracts, it was very clearly said that you still had to keep adequate records. It was clearly said that you still had to publish transparency notices. It was also very clearly said that you had, to the extent possible, keep concern for value for money. Now, in this first wave, I think that the main value was that reminder, because it was very clear there was an extremely urgent need, but there was not a lot of guidance on how to do it. It was just strengthening that there was a permission to go and be more proactive than you would usually. And in that, the European Commission went even further than the UK government, for example, saying contracting authorities can engage in market matching exercises, or they can deploy people in other jurisdictions trying to find things. So it was very much a facilitative first wave of guidance.
Would you have expected that guidance to have existed at an earlier stage?
It would have been desirable, but I think I wouldn't have expected it because it didn't exist in any jurisdiction that I am aware of, because we had not been engaging in extremely urgent procurement at this scale.
So Regulation 32, you made clear earlier, is a rare thing. Presumably its equivalents abroad equally rare.
Yes.
You mentioned that the system in the United Kingdom allows a high degree of discretion, but under Regulation 32 conditions, a very high degree of discretion. Is that fair?
Yes, I think it's almost an unlimited degree of discretion, provided that the basics are complied with. So due diligence has to be in place, adequate record keeping has to be in place, transparency has to be in place, and value for money complied with to the extent possible. Other than that, there's full discretion for the contracting authority to go out and get whatever is needed at the time.
When you touched on that balance between rigidity and discretion in business as usual procurement, you referred also to the need for adequate staffing or the professionalism of those involved in procurement. What is the position in the UK in business as usual circumstances, and was the position during the COVID pandemic so far as that matter is concerned?
So in terms of staffing, I think in business as usual, the contracting authority can gauge to what extent it's capable of running the more discretion-based, complicated procurement or not. So for example, if they don't have a very strong procurement team, they will not be running innovation partnerships, which are notoriously very complex. But it's sort of a self-selected, or there's an adjustment between the capability and the complexity. When we are in an emergency situation, it's not an option. It's going to be complicated procurement. It's going to be messy, if I can put it in those terms. You need to have the capacity. And even if you don't have it, you have to try to do as best as you can. What I think is complicated in that context is to try to think about how to ensure the capacity is there for when you need it. And that's also another theme that I'm sure is going to come up later on. But what you would want to do is look at where capacity lies and put those highly skilled people doing the procurement. You don't want to just bring anyone and tell them now go and buy this very complicated thing in this very messy environment. In particular, you don't want to put anyone that is not very familiar with the rules to do that, because they will probably not even know that PPN 120 exists or what it requires.
All right, thank you for that. I've taken you away from the display. I think you dealt with first wave guidance. Could I ask you now to move on to second wave guidance?
Yeah, so there was a second wave of what guidance that came a little bit later. It would have been guidance not immediately obvious, touching upon emergency procurement, because it was about other things such as transitioning out of support schemes or how to assess the reactivation of contracts as the pandemic evolved. But what I think is very important in that guidance is that there are very fundamental principles of integrity and responsibility that are highlighted. And that wave of guidance is all about ensuring contractors don't take advantage of the public sector, that there is a fair balance of obligations and support, that if contracts have become unnecessary or undeliverable because of the conditions of the pandemic, they need to be revised and, if needed, terminated. And I think those are all principles that should have also been applied in relation to the emergency procurement. So if 2 months after putting a contract in place, it is seen that the contract is no longer necessary, then it needs to be reviewed. If 2 months after putting it in place, it's clear that the contract is significantly disproportionate, particularly against the public interest. That needs reviewing. And I think those principles would have been helpful in allowing particularly contract implementation teams to make follow-up decisions on the rushed initial decisions of extremely urgent procurement.
So would you make a recommendation in relation to that?
So the recommendation I would make is that those principles of responsible behavior, the requirement of honesty and candor, almost an approach to open book contracting, should be the baseline. So it should not be that we treat these transactions as very arm's length, each party trying to get the better bargain they can. I think it's about being a lot more open and collaborative, because in the end, the supplier of the public sector becomes part of the complex organization of the delivery of public services.
Let's move on to the third wave, which features at the bottom of the first part of your box 16.
Yes, the third wave, in summary, was a review of the first wave, and it was fundamentally a review to accommodate the recommendations the National Audit Office had made. So it was a review that clarified specific points. In my view, it didn't change the content of the first wave guidance, but it presented it in a different way. There were perhaps 3 main points that are salient in that third wave. The first one is that maybe the first wave gave the impression direct awards are the first thing you should be thinking about if you're in an emergency procurement, whereas in the revision, direct awards are presented as one, or more clearly presented as one of the different things that contracting authorities can do. They can modify existing contracts, they can call off from those framework agreements. So whereas in the first wave, direct awards were presented top of a list of 5 options, in the revised, they are bottom of the 5 options. And I think implicitly, this comes to say we need to deprioritize the emphasis on direct awards when we are reacting to an emergency.
Thank you, Professor. I want to move on and display your box 17, which is same I&Q number, 000539153, at page 80. It fits within a single page. It's entitled The Applicability of Key Requirements. And you deal here, well, do you want to summarise what you are telling us within this summary box?
Yeah, so I think because of the absence of guidance at the beginning of the pandemic and also the way the guidance had appeared, there's been debate and discussion about what requirements actually applied to procurement during the pandemic. So what I do in that box is summarize and clearly say which I think were the requirements that applied to that procurement. And it's a bit of a long list, but it's probably worth going through them. The first one is that there's no question in my mind that there was an obligation to try to secure value for money to the extent that the market conditions permitted. So this is to say that the guidance was clear that contracting authorities had to take whatever steps they could to try to avoid high prices. And when they were not able to do that, they had to keep a record of it so that it could be audited later on. The second requirement is that they had to engage with emergency procurement to the minimal required extent. And this is as a result of the legal requirement that emergency procurement has to be strictly proportionate to the immediate need of the contracting authority. So they could not buy things that were for later. They could not buy things that exceeded the immediate need. And I think that that assessment of absolute need in the short term was another requirement in all procurement.
Was that a common practice here in the UK in terms of procurement to advance buy?
It's not. And I think it depends a bit what we mean by advance buy. But when we are trying to put, for example, together a framework agreement on one of those highly commoditized issues for the next 4 years, maybe that could be thought as advance buying, or at least we are setting the conditions under which we will buy in the future, but there's no firm commitment. So it could be that we put together, for example, a framework for whatever device is the most technically advanced today, but if tomorrow something new comes in, that framework may just go unused. Because
did it happen much, sorry to clarify, did it happen much during the pandemic, advanced purchasing?
Yes, during the pandemic there was advanced purchasing as far as I can see, because the government was not buying what was required in the next 2, 4, 6 weeks, but the government was buying what they thought would be required in several months' time. And in my view, that exceeded the limit of this requirement.
And is it possible to use Regulation 32 when you are buying for a number of months in advance?
No, it's not. The guidance was very clear that Regulation 42 only allows for something that's going to be delivered immediately, and it has to be fundamentally a bridging solution. So an example I would say is, for example, if you have a cut in your kitchen, you can put a Band-Aid, but you're not going to keep on putting Band-Aids if that doesn't solve the problem. You will go to hospital and get suture. So the direct award is the Band-Aid. It's not the suture.
Understood. Let's go back to your box 17, please. You've taken us through the first few points.
Yes. So it was also required for contracting authorities to adequately manage risks of poor value for money and the potential risk of maladministration. In this case, maladministration because of buying too much or buying things that were not suitable. So I think what that required is, before entering into any further contract, to revise the existing contractual position and to have updated information on whether that contract has been or is likely to be fulfilled. So, for example, as deliveries started to come in, it would be required to see what stock position we have now, how far do we go, are we still in an extremely urgent position or not. The next requirement is that, linked to that issue of aggregate purchasing, when you have parallel entities or parallel cells buying the same thing, you need to have a very clear view in real time that they are not, for example, by both entering into a very large contract on the same date, creating excessive purchase. And also you need to make sure that you're not creating lots of costs that are going to come down the line, because even if having more supply could be seen as desirable in the short line, in the short term, you need to consider how costly it's going to be to stock it, to keep it, and eventually to dispose of it. So I think there's a requirement to look at value for money also in that broader context.
How is that achieved? Is that a data issue?
That's a data issue, and that will require whoever is authorizing contracts to have real-time or as close to real-time data on what the specific position is at that moment.
All right. Thank you. Let's move on within this box.
Then it's also a requirement to ensure the quality and the suitability of what you're buying. And that goes to the issue of the requirement of effectiveness. We said procurement, first and foremost, needs to ensure the public sector gets what it needs when it needs it in the conditions that it needs it. So getting something that is non-compliant is not effective. So they would have had an obligation, to the extent possible, to assure that what they were buying was fit for purpose. They would also have had an obligation to ensure that any shortcomings in quality or suitability of the supplies procured were followed up. It would not be possible simply for contracting authorities to receive something that isn't suitable and let that rest. They would have to then look at what can they do under the contract to either have it replaced, have it reimbursed, or do whatever could be done in that situation. I think they also had an obligation constantly to check that that case-by-case analysis was correct. So this is 2 bullet points down from the one that was highlighted. For every contract, they need to ensure that at that moment, the conditions to engage in the extremely urgent procurement apply. They need to keep a clear record of it, and they need to ensure that the position is not changed because of how the other contracts are panning out. So it's not only about, for example, simply looking, is the pandemic still going, and therefore we can use Regulation 32, but it's more about the detailed analysis of, given everything else we've put in place, do we still need this contract extremely urgently, or has this become something that is urgent but not extremely urgent, and therefore we need to move away from direct awards. We need to go to other mechanisms such as competitive procurement negotiations, for example.
Professor, you don't identify a date, do you, when that change should have occurred?
No, I haven't seen information that would allow me to make that call, but I think what we can say from a matter of principle is that purchases that were trying to create a stockpile for the second wave for after the summer would not have been covered by the authorization for direct awards, because the need was not extremely urgent. It was for later. This was future buying in your terms, and that's not permitted under Regulation 32.
Understood. All right. moving on if we may.
Then they would also have to ensure that contractual performance is being met in all sorts of things, not only on suitability, but also on any other obligations. And in particular, they should not allow any illegal contract modifications. In particular, there are illegal contract modifications where the balance of the contract tilts in favor of the supplier, and that's something that they should have had to look at. For example, not allowing part performance to trigger full payment and things like this. They would also have had a constant obligation to guard against conflicts of interest and to document any measures put in place to try to mitigate them. And I guess we can talk more about the extent of that obligation, but it was a comprehensive obligation. Conflicts of interest are a clear focus of attention in all procurement processes, and it's very, very important that there's not only no actual, but no potential conflicts of interest. And we can discuss more what that means if that's of interest.
Well, do you want to explain what is meant by a conflict of interest in this context?
So a conflict of interest is any circumstance that is going to trigger a biased or non-objective decision in the award of a contract. It could be that there's a conflict of interest for financial reasons, for example, if somebody in the contracting authority stands to gain from the contract, or for personal reasons, if there's, for example, any former colleague that stands to gain, or a family member or relative of somebody that stands to gain. But also, there's conflicts of interest when issues that are not relevant to the procurement are taken into account in making a procurement decision. So, for example, if I am awarding a contract to a specific company because I am worried that otherwise they will go to the press and create public relations problems for me, that is a conflict of interest. And it's what maybe is better termed as an organizational conflict of interest rather than a personal conflict of interest, but it's still a relevant conflict of interest that needs to be identified, mitigated, or avoided.
Have you considered whether there was adequate guidance to those involved in those contracting decisions in relation to conflict of interest?
Yes, there was a specific PPN from 2019, so very recent before the pandemic, and I think that was good guidance. It was quite comprehensive, and it also referred back to further materials that could be taken into account, such as NAO documentation from previous down the line. And I also think conflict of interest is so central to the carrying out of procurement that any public official that carries out procurement will know about conflicts of interest. They will have been asked to disclose them. Probably if they are civil servants, they have broader obligations to disclose potential conflicts of interest. So this was not something esoteric or badly understood.
All right. You next deal with record keeping, which I think you've touched on sufficiently already.
Yes.
And the last two bullets, is there anything you want to draw out from those before we move on?
So I think from the second from the bottom, it's very important that there was a very stringent requirement on transparency. So it's not only that record keeping had to be kept, but there was an obligation to proactively publish transparency notices. And basically, the short of it was that within 20 days, at least until June of 2021, within 20 days from the award of a contract under this direct award mechanism, the contracting authority had to publish details of the contract and even a redacted version of the contract itself. So it was a stringent requirement for publication, but it was, in my mind, there's no question that that had to be complied with. And the issue that is not so clear in that period is to what extent a contracting authority that is engaging in direct awards has an obligation to keep a minimum of competition where possible. I think that there is judicial authority that suggests that, but I think that that's incorrect. And I think there's also judicial authority to the contrary that says once the use of Regulation 3032 is allowed, there's no obligation whatsoever to engage in any sort of comparison or mini competition.
All right, Professor, one final topic and one final box before we move on to your assessment, your analysis of some of the events of the pandemic so far as procurement is concerned. It's box 18. It's the same I&Q number 000539153. It's already up on the screen. At least the first half of it is there. And it's your assessment of the applicable legal and policy framework. How did the applicable legal and policy framework stand up to the test of the pandemic?
So I think the legal and policy framework was adequate in that it foresaw the possibility for extremely urgent awards, and it made clear what specific obligations had to be complied with. It's true that we didn't have guidance before the pandemic, but it's also true that guidance was produced relatively early on in the pandemic. And in that regard, I think the guidance was helpful and implementable. What I think is perhaps the most important point I try to make in that box is the one that crosses over to the next page at the top, which is that the issues that have arisen and that are the object of this module are not triggered by having incorrect rules or insufficient policy. The issues are about staffing. The issues are about decision-making. The issues are about what information is available, what data is available at the point of making difficult decisions in a messy environment. And I think that's the crucial issue, because we will not get better emergency procurement in the future by drafting a rule in a legislation or by drafting a policy document that is more detailed. We'll have better emergency procurement in the future if we have better data, if we have better systems, and if we have a more professionalized workforce that can be deployed at scale.
And those presumably are recommendations you would make for the future?
I would make definitely those three recommendations. I think that the way that procurement data is collected and is shared needs revising, and I don't think that the Procurement Act goes far enough in that regard, and I can build on that. I don't think that the systems are sufficiently developed, and I think 20 years after e-procurement became mandatory, e-procurement is still not the absolute norm and doesn't work seamlessly in the UK, as it also doesn't do in other jurisdictions. And I think that the level of training and capability development requires looking at it, not only but also in relation to digital skills. So I think we need a significant upgrade. Having said that, those are all complicated, expensive to deliver mechanisms. So it's also not a matter of recommending something that's going to be a magic bullet. Some of these things are just incremental, will take time to develop.
Well, I will ask you to build on that in a moment when we come to the next stage in your evidence, so to speak. Is there anything else you wish to say in relation to how the UK and its applicable legal and policy framework stood up to the challenge of the pandemic?
So I think the other important thing to say, which is further down the line in that box, is that one of the things that can help when you have a systemic emergency is to have a centralized mechanism to react to it, and to have an entity that has the capability and has the expertise to try to go to market in those difficult circumstances. In other countries, that centralization had to be put in place when the pandemic hit. But in the UK, I would have thought the position was strong going into the pandemic, because we had specialized entities for centralized procurement for the healthcare sector in each of the devolved nations. And in particular, NHS supply chain had been put in place 2 years or 3 years before the pandemic hit as an entity tasked explicitly with creating framework agreements and commercial vehicles for healthcare supplies. So I would have expected this was a center of expertise, that this would have the staff with the knowledge to be able to deal with the pandemic when it hit. And I think the events have shown that NHS supply chain in particular collapsed really early on in the pandemic. And I think that to me was quite surprising. I wouldn't have expected a £250 million organization tasked only with buying consumables for the healthcare sector to just fundamentally be unable to cope with the increase in demand, even if it was unforeseen. I also would not have expected that organization could not be strengthened, and we would rather have to create completely separate organizational arrangements rather than growing it or developing it.
But again, those aren't observations that relate to the robustness or adequacy of applicable legal and policy framework. They are observations that you make about the systemic or structural failures. Is that right?
No, I think they have to do with policy, because the policy for the healthcare sector had been to centralize. The policy for the healthcare sector had been to resource this organization. So in terms of policy, you would have expected that if there's a healthcare crisis, we would not expect everyone in the public sector to have to start figuring out. We would have had a single point of focus. So it's not a matter of the failures that followed. It was a matter of the policy choices the UK had made. And I think NHS supply chain was also heavily involved with the management of stockpiles, for example. So it should have been an organization, from a policy perspective, expected to own the response and expected to guide the response. And this is a matter of the arrangements in place. It's not a matter of how they didn't work afterwards.
And so what concrete recommendations would you make to avoid a repeat of that set of circumstances?
So I think the recommendations tie closely with what the second Boardman review said and what this inquiry has been told has happened, which is that a significant review of how NHS supply chain operates was required, and that a change of working processes, a change of IT systems, a change of how many layers of subcontracting exist in the NHS supply chain had to be taken a close look. Unfortunately, on the basis of the public information, I cannot come to a view as to whether that has been done properly or sufficiently, because I don't know what it means, for example, that PPE procurement has been brought back in-house within an NHS supply chain, because that's all that's been said. I would need to know how many people, with which resources, what sort of stress testing they are conducting. I would need to know how they are trying to ensure security of supply, how they're trying to engage in diversification from markets other than China and other Far Eastern countries. So there's a lot that would need to be done to check that what we have been told has been done in the way that is correct. So this is to say, just because my recommendations would be fundamentally, let's do Boardman with a couple of more things, that doesn't mean that those are irrelevant, because I'm not sure that we are far enough in the process of those reviews.
Thank you, Professor. I want now, with all of that background, you were starting to touch on particular features of the pandemic so far as it relates to procurement in the UK in your last remarks. But I want to turn now more directly to two topics that you have explored through your consideration of some of the witness evidence that has been obtained by the inquiry. You considered, did you not, a number of those witness statements that were provided to you from material providers?
Yes.
Particularly DHSC, Cabinet Office, witness evidence, and other evidence. Is that right?
Yes, they are listed in Annex 2 of my report.
You have an annex in which you list the material that you looked at.
Yes.
And you have sections within your report that deal essentially with two matters that arise out of that evidence. Firstly, the PPE parallel supply chain, including the VIP lane.
Yes.
And secondly, the ventilator challenge.
Correct.
And you've considered both of those matters, and you offered your reflections in a quite detailed set of sections within your report.
Yes.
Yeah. And that's what I want to move on to now. I want to hear your response to that evidence. We will, of course, be hearing from some of the authors of those witness statements in due course.
Would you rather take the break now, Mr. Wall? Just thinking it's up to you.
It may well be convenient, my lady, if that would suit you. Yes.
I was just thinking the stenographers probably had quite a morning.
I'm sure that would be welcome. Yes.
Very well. I shall return at 25 past. All rise. Mr. Wald.
Thank you, my lady. Just before we paused, Professor Sanchez-Grayas referred to an annex at the back of his report detailing or listing the statements which he considered in the course of assessing those two or three matters, the PPE parallel supply chain, the VIP lane as part of it, and the ventilator challenge. I wonder if we could just have that annex, it's Annex 2, put up on screen. Is that the annex to which you were referring, Professor?
Yes, that's the annex.
Yeah. And you have read and considered all of those statements for this purpose, have you?
Yes, I have.
Yeah. And we can see that they come from various sources and, of course, across the devolved administrations. And then we can see that it goes on to a second page, and equally the same applies to those listed in the second page.
That's correct.
All right. Thank you very much, Professor. Can I then ask you to turn to page 120 of your report? It's box 19 of INQ 000539153 again. And this is where we have the benefit of your reflections, having considered that evidence, first of all, so far as it relates to the PPE parallel supply chain, including the VIP lane. I want to start off with that. And let's take this slowly. It's detailed stuff. And I would ask you to use the box in order to provide your oral evidence now, please.
Thank you. So, as we were saying, before the pandemic, there was a centralized mechanism for the procurement for the healthcare sector in the UK, which was the NHS supply chain. The NHS supply chain was fundamentally run out of an entity that's called SCCL, which was an arm's length company owned by the Department of Health at the time. So that's what SCCL refers to in the box and what I will refer to. But so NHS supply chain or SCCL mean the same thing for these purposes. And what is clear in the evidence is that despite the department instructing SCCL to significantly ramp up the procurement of PPE at the beginning of the pandemic, in short, SCCL was unable to do that. They were overwhelmed by the amount of PPE that was required. They had significant supply chain disruption in that some of the providers of the frameworks they had in place could not come through and could not fulfill orders. And they also were not able to accommodate a significant increase in their workforce. The way it's presented is fundamentally because of IT constraints. So the IT systems that they used could not grow to the number of users that would have been required. So when the collapse of NHS supply chain became obvious, the department decided to step in, and they decided to step in by creating this parallel supply chain, fundamentally for PPE.
When you say the department,
I mean the Department of Health and Social Care.
Yes, fine.
And it also is important to say that although this was owned and led by the HSC, the implementation of the parallel supply chain was done by Cabinet Office in significant ways. So it's very much, in my view, a joint endeavor, even if the final formal responsibility for it lay with the Department of Health. And this parallel supply chain tried to reach different alternative providers for PPE. So one of the things that they did is, of course, continue engagement with existing providers to the NHS supply chain, but then they were trying to find new providers for PPE. They were also trying to more focusedly buy PPE from China specifically. So they organized their activities according to the type of provider that they were seeking to tap into. And the important change of policy at that point in time is that up to the point of the creation of the parallel supply chain, each NHS trust could decide to buy PPE on their own, or buy it collaboratively with other NHS trusts, or buy it through the NHS supply chain. So it emerged that we were in a situation where there was also competition between buyers to try to get into the same sources. So at some point it was decided this parallel supply chain for PPE would be the only buyer of PPE for the healthcare system. So it created this single point of procurement.
Presumably your view is that that was a sensible move.
That was a sensible move because you don't want different parts of the same system trying to outbid each other in trying to get the same procurement. And it would also have been something relatively natural to do, given that PPE had already, and like every other healthcare procurement, had been progressively been centralized. So it would not have been a massive departure from how things were done. So it should have been relatively attainable, I think, in terms of policy and approach.
All right.
Now, the way that the parallel supply chain was structured was in part built from scratch, but in part it absorbed the team that was trying to buy PPE for NHS supply chain within SCCL. And what in my report I identify is that, in my view, there is not a joined up understanding of the interaction between the SCCL PPE team and the new organization being put together. In the accounts I have read, SCCL comes to say they ceased having responsibility for PPE procurement the moment the Department for Health stepped in. And all that happened is that some of the subcontractors of SCCL, the so-called category tower service providers, loaned some stuff to the new cell, and the systems were used to facilitate some awards within frameworks, which would be, in my view, a very distanced and arm's length understanding of the role during the pandemic. Whereas in the accounts from Cabinet Office and the Department for Health, it's the opposite. It's basically said the SCCL team was taken as was, and yes, was formally included under the new organization, but they were tasked with independently trying to continue procuring from the known providers, and they were tasked with exploring with those providers and their market knowledge which other providers could be identified within that remit, but they functioned fundamentally independently. So I think that's a first point of reflection, how joined up the existing structure and the new structure were, and also could it have been done differently? Because I would have imagined that once the SCCL team is embedded in the broader organization, their expertise could have been spread more widely. Rather than keeping it as an independent team, they could have kept some of that team and brought new workforce to the tasks that could be easy to delegate, but then use some of that expertise to support the new bits of the new organization.
That have been done without unduly reducing the staff that were made available.
So I think, to me, it's not a number of numbers. It's a matter of the expertise, because it's probably easier for someone that doesn't know much to be brought to say, these are the existing suppliers, these are the existing products that we know, have conversations with them about how far they can go. I think that's easier to delegate to someone than to keep all of that expertise in one silo and then try to bring people that will have to learn which suppliers exist, what products are bought, what those products look like, and have any historical understanding of these things. So one thing that might have been done differently is not to keep the teams so separated, but to have the experts from SCCL support the PPE cell more broadly. The other thing is that the way it is presented, the new organization grew very, very quickly. So at its peak, I think it had 508 members of staff. So there was a lot of people trying to buy PPE. Of those staff, about 50 were coming from Cabinet Office, from different bits of Cabinet Office. All the members of staff were coming from other government departments, or were coming from NHS England or NHS Improvements. But there was also significant reliance on external consultants. So the makeup of those two parts of the parallel supply chain, the SCCL sort of existing team, expected to be highly skilled and knowledgeable, was very different from the makeup of staff in the rest of the parallel supply chain. Despite this not being as integrated as it could have been, maybe, the accounts are that the procurement outcomes that were being achieved through these two tracks within the PPE buy cell were aggregated, so that on the daily dashboard that was being circulated, the procurement from SCCL was featured. So when the rest of the PPE buy cell was buying, they were doing it in the knowledge of what could be provided by existing suppliers. And the amounts came to be almost 50-50. So looking at the numbers, and there's a bit of the discrepancy in the numbers provided to the inquiry, but looking at the numbers provided by the Department of Health, it would look like the SCCL PPE team managed to buy about 4.2 billion of PPE in the relevant period. Then it goes up to 5.2 billion in the extended period, out of the 8.6 billion that the PPE buy-sell procured in total. So they managed to do about 50% of it. So to me, that also makes it a little bit difficult to understand what did they mean by collapse of the supply chain in the early stages of the pandemic. And if that supply chain had collapsed, how could it still deliver 4.2 billion of PPE? So I think there's issues of timing of decisions and timing of reaction from the markets that to me have been very difficult to understand on the basis of the accounts, and that might be an issue that the inquiry might be able to go further than I have been. But this is to say, the SCCL procurement of PPE was not insignificant and was not minor. It was very large. Now, moving on to how the new bit of the organization, the PPE buy-sell, was organized. It was created on the 21st of March of 2020, and it was initially comprised by a very small group of senior civil servants that then grew up to that very significant organization of 500 staff. And the way it sought to organize itself was through the sequence of procurement that I think you also described yesterday in your opening submissions. They understood that the team would work on the basis of receiving and screening for opportunities, engaging with technical assurance, and then closing or setting the commercial deals. So it's described as a very linear process. And it's also described as a very segmented process, in that each of those tasks would be carried out by a different team. And that would be very important when we come to the VIP lane. Now, this structuring was always meant to create a closing package that would be sent to the Department of Health for final approval and award. So this is also very important because from the accounts I've been able to read, even if there were different tracks for the procurement of PPE, even if there were numerous opportunities teams and there were loads of staff involved, in the end, the decisions on the award of contracts were made by a small number of very senior civil servants who should have had as full documentation as they could have. So, for example, in relation to complying with transparency requirements, it would not have been difficult to use that focus point for the collection of the relevant information, right? So I think it's important in that it was a very devolved organization that funneled into a very single point of decision-making. And that single point of decision-making is going to be of particular interest to the inquiry, I think. Talking about that decision point, until the 5th of May of 2020, these closing packs or deals were sent for approval to the department, and the approval was done on the basis of delegated authority, as you also explained yesterday. But from the 5th of May, probably trying to make this process more robust, a clearance board was created. And that clearance board was given 1 to 2 page summaries of the closing deals to try to provide additional scrutiny of those deals. At least that's the way it's described in the submissions.
Did it bring advantages, this change in procedure?
So I think it probably would have brought some advantages in that it would have avoided single decision makers under significant pressure making very high stakes decisions. It should have created a space where you could have a more critical, a bit more distanced analysis of the deals. And also the threshold, even if it's £5 million, at that time, that was probably a relatively low threshold at which to scrutinize deals, given that all the deals were quite large. And I think this would also have had the advantage that it would have created more requirements for documentation, because in addition to the closing pack, you also had to create that summary. What I was a bit disappointed, if not surprised to find out in the evidence, is that those deal packs then sometimes were put together after the clearance board had looked at the summary. And that makes some intuitive sense, because when you have little resource, you don't want to put together a comprehensive deal pack if the clearance board is not going to endorse the deal. But I don't understand how you can create a summary of documents that have not been compiled. So in terms of advantages, I think it may actually have created the disadvantage of having the scrutiny of deals on the basis of really high-level, very succinct information, rather than fuller closure packs. But that's something I've not been able to test in reality, because I've not seen those documents.
So the full pack was assembled after a positive decision?
At least in some occasions.
And the positive decision was based on a high-level summary only?
Yes.
Understood.
1 or 2 pages, which of course would not have provided lots of detail on the specifics or the contractual requirements in that award. And until that point, it's also important to bear out that according to the government's own internal audit, the track record of due diligence and the record keeping until the clearance board was created was inconsistent, and sometimes no records were kept of awards made before the clearance board was put in place. So to me, that will also be a significant issue, because as we said throughout this morning, there's an obligation of record keeping, there's an obligation of transparency. If records are not created and are not kept, we cannot possibly scrutinize what's happened. So there are some awards that apparently even it might be impossible for this inquiry to look into because there's no records for them. And that would be a matter of concern to me. Now, this is to say, the buy-sell was designed to operate in these sequential opportunities, technical assurance closing, with increasing elements, if you want, of oversight through this clearing board. The other thing that changed through time is that when the backlog through the PPE cell started to grow, one mechanism to try to accelerate the award of contracts was putting together rapid response teams. This seems to have happened from the 24th of April, so about a month into the working of the PPE buy sell. Those rapid response teams would have had member staff from opportunities, a member staff from technical assurance, a member staff from closing. And they were trying to put deals together in 1 or 2 days. If they saw that they would not be able to do that, they would send the opportunity back to the standard non-rapid response opportunities team to progress. What I think this also shows is that the segmentation of activities was not always happening. We had teams that were doing all of activities at the same time. And I think that is an important point to bear in mind when the inquiry will hear that the teams were insulated from each other. For example, the technical assurance could not possibly be influenced by whatever was happening at opportunities when you had rapid response teams that integrated all members of staff. And I think we've been given some numbers. I think 21 contracts were awarded through these rapid response teams, but I've not been able to see how many of those, for example, were from the VIP lane and which ones were not.
Well, I was going to ask, is the rapid response team distinct from the VIP lane, or there may be overlap between the two?
So I think there may be some overlap in that some VIP lane opportunities were dealt by rapid response teams, and some of the VIP lane members of staff participated in rapid response teams as the opportunities person for that opportunity. But as a matter of design, if you want, they are separate things.
So you wouldn't necessarily require a VIP referral into a rapid response team determination, whereas you would into the high priority lane or the VIP lane?
That's my best understanding of the evidence.
All right. I know you're coming on to the VIP lane in a moment, but
Yep.
I wanted to ask that question in relation to the two.
Yeah.
All right.
Also, because the rapid response team was only created from the 24th of April, there would have been BIP and non-BIP contracts progressed before the rapid response teams even existed. So
Because the VIP lane was established on which date?
that's further down in the box. but I think
it predated in any event.
It predates the rapid response teams in an event. I am not exactly sure. I think it was the 2nd of April, but I would need to double check the report.
Okay, we can check that. Yeah. All right.
So within this PPE buy-sell, there were 4 routes to contract, and here is where the account from Cabinet Office and the account from Department of Health slightly varies, because the Department of Health includes the make route within the PPE broader cell, the way it's described. But for the purpose of this account, I rely on the Cabinet Office's description of it. What's been described to the inquiry is that the PPE buy-sell run 4 routes. Route 1 would be the NHS supply chain route, where the existing PPE team was trying to buy from existing suppliers. They would run an open source route, or maybe the call to arms route, which was any offer being sent for PPE through a varying approach to web forms and SurveyMonkeys, and we can talk about that later. There was the 3rd route, which was the VIP lane, which was only for offers referred by an MP, a minister, or a senior official. And a 4th route, which was the China buy route, which was fundamentally distinct in that it was run with a lot more involvement from the FCDO. So for the purpose of this report, setting for now aside the issue of how the NHS supply chain fed into all this, the 2 routes that are important are Route 2 and Route 3. So basically the open to anyone route and the referrer only Route 3, VIP lane. And I think it's important to get to the bottom of why and how the VIP lane came to exist. And I think there's a mixture of reasons for it. The first issue that is quite clear in the evidence is that there was a big concern about PPE. Everybody knew that there was a shortage, so companies that could provide it and any other parties were sending their offers for help to all sorts of people, senior civil servants, ministers. So there was information already being sent to the system. And the initial approach was to collect those offers for help and route them through NHS supply chain, and within that, through a subcontractor. But that amount of information significantly grew to the point where there was the impression, and I think the impression is borne by the numbers, that this was not a very reactive mechanism. So people were sending offers for help and were not hearing back. So we have a first issue with information not being treated in a timely way. What would happen then is that those with political connections or those with access to an MP would escalate that and say, in simple terms, I have offered whatever many masks, I haven't heard back, can you chase?
Just pausing there for a moment, to be clear, offers made outside the high priority lane or the VIP lane, was there an expectation or a practice of those making the offers? There weren't referrers in that context, so those making the offers hearing back in the way that you describe. Did that happen outside the VIP lane?
No. So for anyone making an offer, they would basically fill in a SurveyMonkey or a more structured web form down the line. They would receive an automated response saying, please bear with us, and they would have to wait until something was pursued.
And did that even apply to the rapid response teams that weren't dealing with, when the time came, high priority lane or VIP lane offers?
So I think there is a timing issue there. So in principle, yes, but I am not sure if by the time the rapid response teams were created, all of these open source offers would already have been triaged through the separate call center that was put in place. So it could be that there was some engagement before a rapid response team was ever involved. But fundamentally, any offer that was not referred was sitting and people had to wait until an opportunities team or the call center that was put in place later looked at it and established first contact to verify, is the offer still valid, and get some more details. But there was no way they could ask for updates on what's happening with my offer.
All right. You were telling us about the requests or the demands for updates within the VIP lane?
Yes. So what happened then is that those that had made an offer and had not heard back would be seeking for their MP or a member of the government at the time to chase. And those chases were sent to the PPE buy-sell. In the accounts that have been provided to the inquiry, it's clear that that was a significant volume of communications, that it was a significant draining on the resource of the PPE buy-sell because the opportunities teams were spending a lot of time replying to those chasers, and therefore they were not having all the time to look at the offers that they had received. Now,
No automated responses?
not as far as I know. I think there was an attempt at some point by some civil servants to put an automatic response saying, we have received this, we will be in touch. And that was also very quickly escalated. So basically, those chasing were not willing to take an automated response or a please wait and let me do my job answer. They wanted to know specifically what was going on with the specific offer that they were interested in at that specific point in time.
All right.
So faced with that challenge, instead of seeking to educate those sending chasers on the importance of freeing time for the civil servants to do their job, instead of sending out basically general communication saying, we're going as quickly as we can, we need to use all of our time to that, please don't chase. And also, please don't chase, because chasers from senior government people or MPs put pressure on these teams that are already very pressurized. Instead of taking that approach, instead of the senior leadership of the PPE buy-sell, when they received those escalations saying, what does it mean I got an out of office? What's happening with my offer? Instead of going back and saying, that's the absolutely appropriate response. You don't need to hear more about this now. Instead of them maybe organizing some communication about how this PPE buy-sell was being put in place, how it was operating, so that general assurance was given that opportunities were being looked at, rather than specific assurance about specific opportunities. They decided to do the latter. So they decided to create a specific dedicated email address that would, and of course, a dedicated opportunities team to work on the basis of that would only look at opportunities that had been referred by ministers, MPs, or senior civil servants. And to me, that doesn't make any sense, and it's not in line with the principles of procurement we were talking about. One of the key worries in trying to avoid corruption in procurement is to pay very detailed attention to what politically exposed persons do. We know that somebody in a position of power can influence procurement decision-making. So creating a dedicated communication channel for politically exposed people to chase opportunities and potentially pressurize procurement decision-making is just completely contrary to the principles of public procurement. And in my view, although this inquiry has been told this was a legitimate operational requirement because we needed to free time from the frontline civil servants that were looking at the opportunities, to me, that's the wrong end of the stick. The legitimate operational requirement was to get the MPs and to get the ministers to wait like everybody else. So they addressed a challenge in the worst possible way in a procurement context, in my view. And this inquiry has also been told it didn't really matter in the end because it was only the entry point. It was only about getting that feedback that was more timely. But I think the evidence is very clear that there were significant differences of treatment. It's not only that there is already a judicial finding of illegality of the VIP lane because it didn't provide equal treatment, but it's that it was foreseeable at the time that if you have not particularly experienced members of staff with a new challenge in a very complicated, high-pressure area, having repeated chasers, knowing that at the other side of an opportunity there's not only a company, but there's also a political figure, would have necessarily changed the way they approach things. And we've also, or this inquiry has been told, this was an opportunity stage issue only. But then VIP offers were sent for technical assurance like any others, But the evidence shows that technical assurance ended up appointing a specific person to deal only with VIP offers. So it's not accurate to say all offers were treated the same from a technical assurance perspective, because technical assurance was taking time, and having a dedicated person for technical assurance of VIP offers would have accelerated things. The inquiry has also been told that acceleration didn't actually happen. In the end, the processing times of VIP offers and other offers ended up being roughly the same. But that's not something that those creating the VIP lane could have known at the time. And if anything, the intent behind creating the VIP lane was precisely to create speed. Speed in reacting to the opportunity, speed in getting the opportunity to contract. So the explanations given in terms of mitigating or contextualizing the impact of the VIP lane are, in my view, not persuasive at all.
Well, we'll come on to the relative speeds of processing within the VIP lane and outside it in due course, but you've mentioned one of the High Court judgments, the Pestfix judicial review claim, in which a finding of unequal treatment was based on a difference in relative speeds of processing between VIP lane and non-VIP lane offers. What advantage, if any, does speed of processing offer in the context of pandemic procurement?
So in the context of the pandemic procurement, we are back into extremely urgent procurement. And we already said this morning, one of the key requirements in extremely urgent procurement is that it can only comprise what is strictly needed for the satisfaction of the immediate needs. So this was not an exercise meant to screen all possible opportunities without end. This was, by necessity, a time-limited exercise where at some point, if things went well, the UK government should have taken the view, we now have enough PPE for our immediate needs, we now move to competitive procurement. So there was an uncertain, but by legal requirement, proximate endpoint to the emergency award of contracts. In other words, at some point, it would not be possible to get a direct award anymore. And that could make the entire difference. If you had been processed quickly, you would be in the initial awardees of contracts. If you were taking longer, you might miss out because the cutoff for the direct award would have run out. Now, in the event, because the UK government ended up buying so much PPE for such a long time, it could be that in the end, all opportunities were looked at. But that was not what was required at the time. That was not what was permissible at the time. What was required is to buy the PPE we need right now in the best possible way we can, and then transition out of this emergency procurement. And I think that's what the time advantage goes to. It's a matter of time advantage in principle. In an emergency situation, by definition, being considered first is an advantage.
And leaving the rate or the speed of processing of offers inside and out of the VIP lane to one side for a moment, what is said in some of the witness evidence, including some of that which you considered and features in your schedule, is that the offers that came in through the VIP lane that were referred in were inherently more credible or better offers. Have you had an opportunity to consider that point?
So I have considered that point, and I think there is also significant evidence to the contrary. I think there's evidence in front of this inquiry that at the time of creating the VIP lane, those in charge of the VIP lane were expecting to operate like a sewer, I think, and that the role was mainly to take noisy offers out of the system. So the expectation was not that the VIP lane necessarily would bring those better offers. The other thing is that it's clear that there was a big disparity in the types of offers that went through the VIP lane. And there was also confusion about whether VIP or high priority actually meant political referral or high operational need. So the other thing I have also not been particularly clear on, after reading all the evidence, is whether some high-quality offers ended up in the VIP lane by mistake, if you want. So they were not being referred by a politician, but they were forwarded to that team because it was understood to be high operational priority team, and then they progressed them. I think there's evidence in front of this inquiry that the VIP lane, on occasion, processed offers that came from Route 2. And what I've not been able to see is how many of those cases we had. So I think the people making these decisions didn't really have the expectations that VIP lane offers would be particularly credible or better. They were concerned about managing the pressure exercised. And I think that's what's really crucial, because what is relevant in understanding decision-making is what information is available to those making the decisions, how reasonably we can expect them to anticipate problems in making those decisions, not necessarily what happened after the fact.
What advantage, if any, did processing through the VIP lane confer on a supplier or an individual offer? And I draw a distinction between those two because, as you will know, some suppliers secured multiple contracts pursuant to multiple offers.
Yes.
So are you able to provide the inquiry with answers to both aspects of that question?
So I think in terms of a supplier, I think the advantages to a supplier were that they had an immediate way of first putting weight on their offer, because the fact that they were referred meant the offer was being progressed, even if their offer might not have been progressed on the basis of the other triage criteria. For example, the Department of Health has explained that in the open route, the initial sifting at the early stages of the pandemic was carried out by size of the company, size of the offer. So, for example, a very small or newly created offerer, supplier, that had a political connection probably jumped over the first hurdle, but they wouldn't have in ordinary triage. Because if you had a balance sheet of £10, triage would not have progressed you. But if you had a balance sheet of £10 and were referred by a senior minister, you were followed. So that's a significant change. And then it also allowed for a channel to continuously push for the processing to be moved forward. It's not true that the VIP lane only engaged at the opportunity stage. The VIP lane could provide updates once the offer was sent to technical assurance, once it was with the other phases of the procurement lane, because each of those teams had a dedicated person that the VIP lane staff could ask for updates about. So the other advantage as a company is that you had a lever to keep pushing for your offer to be taken to deal, whereas other companies didn't have that.
And in terms of that pushing, one consequence is rate of processing. Did that pushing enable adjustments to be made to the offer, or an iterative process?
I haven't seen evidence to that. I don't know.
All right. That's very fair. Thank you. In terms of the outcome, though, what were the prospects, improved or otherwise, of an HPL offer compared to a non-HPL offer, or the prospects for an HPL supplier compared to a non-HPL supplier?
So at the supplier level, I think we had loads of individuals making very difficult calls on very limited information. And probably nobody wanted to be the one that missed out on a good opportunity for being too strict on specific things. So I think that significantly changed the likelihood of HPL contracts being awarded to suppliers. Because when information indicated, for example, a borderline situation, I would have expected individuals to make that decision to think twice before saying no, because they could expect follow-ups. I think this is human nature. So I think, I haven't seen detail of it, but I think there's a very strong indication that in close calls, VIP had an advantage because of the pressure on the decision maker.
Well, you've included in one of your bullets, this is on the second page, 3 down, 10 to 1.
Yes.
Improved rate of success per supplier.
That's the outcome.
That's the outcome.
Right? So what resulted as probably an effect of this systemic pressure to get VIP deals concluded is that VIP suppliers were 10 times more successful on the basis of the evidence I've been able to see. I know you showed yesterday data that says it's actually 17 times more successful.
Well, that's if you look at offers rather than suppliers.
Okay. So the distinction between suppliers and offers is also something I cannot fully appraise because I've not seen a breakdown of suppliers and contracts or offers. But what I would have imagined is that under the VIP lane, because this was about supplier being referred, everything a supplier had to offer probably was progressed quickly. So say a supplier was offering FPP3 masks and gloves, probably they were both looked at the same time, whether the priority that day was to buy gloves, but maybe not FFP3 mark. And that's what I imagine might have happened. And that's what probably shows that by offers, the success rate is even higher than by suppliers. That's how I would understand the evidence.
All right, but let's stay with the 10 to 1 figure that you include in your report then.
Yes.
You may have touched on this, but I want to be absolutely certain of your evidence, if I may. If it is said, and it is said in some of the evidence, that 10 to 1 comparison simply shows how helpful, how useful, how effective the HPL was, what is your response to that?
So I think that would only make sense if the evidence at the time showed that fundamentally all of the VIP lane offers were significantly better and all of the open source offers were really bad. But that's not what the contemporary evidence shows. The contemporary evidence shows that the VIP lane brought a mixed bag of offers. And that's why a 10 to 1 ratio is really surprising. You could expect some variation, but not 10 times fold. The other thing that I think is also interesting in that is that the 10 to 1 in terms of supplier by headcount, if you want, is also something that needs to be looked at more broadly. In the end, about 50% of the value procured by the PPE buy sell went to VIP lane contracts, so VIP suppliers. And that's even more stark. So I think it doesn't come naturally to say, because VIP offers were better, they fundamentally made up 90% of the awards, which is what 10 to 1 means.
Understood.
Could I just ask a question? Sorry to interrupt.
Of course.
When you say the contemporary evidence shows the VIP lane brought a mixed bag of offers, what is the evidence that they're relying on, just for my notes?
So in witness statements, you have been told that there were lots of very noisy offers that didn't fall through, that lots of the offers through the VIP lane were actually contacts that never borne anything. So you will have statements by, I think particularly the PPE lead cell, that shows that they were not getting particularly better offers.
Thank you.
Unless you wanted to say more on that particular point, I was going to take you to the bullet point below, the one that starts the VIP lane.
Yes.
You indicated earlier one particular principle that is offended by the VIP lane, and that was the involvement of ministers. But here at this bullet, you say that it did not meet most of the requirements applicable to procurement during the pandemic. Which of the other ones arise or are offended?
So what we said is that in extremely urgent procurement, the obligations are to keep records, to proactively publish transparency of contract awards, and to screen for conflicts of interest. All of those are offended by the VIP lane. First, and the PPE buy sell more broadly, because there were no adequate records kept, especially in the initial stages of the functioning of this cell. And I think this is particularly shocking to me because when the process for the procurement in those 8 stages that you described yesterday was designed, according to evidence submitted by the Department for Health, and I think this is in figure 9 of the submission, in stage 7, there's an explicit reference to Reg 84 report. Reg 84 basically is the obligation under the rules applicable at the time to have a full record of decision making and to have the specific information that is going to be required to publish a transparency notice. So when the cell was being created, there was an awareness that this had to be compiled and kept, but didn't happen. And there's plenty of evidence that records were patchy or didn't exist, and this has been criticized in the government's internal audits and also by other oversight rules. So I think that's incontrovertible. So there was insufficient or non-compliance with the obligation to keep records. There was also massively delayed and until today, to the best of my knowledge, still partial non-compliance with the obligation to publish contract award notices and contract details. It's been recognized that I think it's 94% of the contracts awarded through the PPE by cell were late in publishing transparency notices. So that's also a breach of that requirement.
Is that a problem in practical terms? If they're published, albeit late, does that create problems of transparency?
It creates very big problems of transparency. So,
very big?
Very big. We need to think about what is the purpose of those notices. The purpose of those notices is to disclose to the public how, under extreme urgency and pressure, government is making decisions. I don't think it's outside the realm of possibility that if some of those extremely high value awards to extremely inexperienced suppliers had been put in the public domain in a timely fashion, there would have been some mechanisms to maybe even prevent those contracts from ever being implemented. So it's extremely important in a situation where there is no forewarning, there's no planning of what's going to happen, when things are presented as a fait accompli to society, that happens as quickly as possible. And I think there was an awareness, at least in some of the evidence I have seen, that transparency would have triggered criticism in public opinion, and therefore it's almost justified in some of the witnesses' evidence to not have provided that transparency to avoid that public scrutiny at the time. And I think, again, that's a very significant violation, not only of the requirements under the law, but also the spirit of the law.
Understood. And you deal in your, it's not your penultimate, it's your anti-penultimate, because there's another bullet point over the page, but you deal, the penultimate one on this page, again with the High Court decision.
Yes.
On the VIP lane, that it was unlawful on grounds of unequal treatment.
Yes.
Due to the speed of processing.
But also, not only due to the speed, but due to the fact that for a spurious reason that had nothing to do with the content of the contract to be awarded, there was a triaging of those offers through the VIP route. So what the court says, and it needs more recognition, is that preferring an offer simply because it's been referred by a politically exposed person is not a legitimate ground in the context of procurement decision-making.
Yes, although it's right to point out that in that case, the contracts under consideration were found to have been ones that would have resulted in grants of contracts in any event. The offers would have resulted in awards.
That's fair, but that goes only to the point of remedies.
It does.
And I think that's important to say. The issue of remedies in procurement is a difficult one because once a contract has been awarded and basically fulfilled, there's nothing the court can do but eventually grant damages. And in the specific context of that litigation, damages was not a great remedy to give because of the type of claimant that we had, but also because it maybe would have been seen by the court to add offense to injury. So I think that's important to put in context. The other thing that is important is that I think this inquiry has been given evidence that in other case contracts, the decision probably would not have been to in any way award the contract through the VIP lane. So I think that the richer and broader evidence in front of this inquiry will allow for a more nuanced and more comprehensive analysis than the court could do at the time with the evidence in front of them.
Of course, the court is focused on the limited parameters of the claim that is brought before it. Yes, that's quite right. The bottom bullet on this page tells us what perhaps may be already apparent from your evidence, which is that you are unpersuaded by the rationale or the reasons for the creation of the VIP lane or its justification. But I want to ask you this. To those who say that the government faced a Herculean challenge to acquire at speed vitally required PPE and other procurement materials, it was deluged with offers. It needed to enact some system of prioritisation. What do you suggest as an alternative method of coping with that would not offend the principles to which you have referred?
The alternative method was inside the PPE buy-sell itself. The criteria for prioritization for Route 2 were fundamentally looking at the credibility of the offerer and the content of the offer. And that would have been appropriate. So in a context where the government receives more offers than it needs or that it can process, it should prioritize on the basis of which ones are more likely to lead to a contract. That's the relevant criterion to look at. And it can be difficult to implement, but in that case, it is legitimate. So, for example, it could have been that the government decided we don't engage with any company with less than 3 years experience of PPE because we don't know if they're going to be able to source it or not. Or we don't engage with offers for less than 1 million items because it's not going to be worth it in terms of logistics. Anything that is operational or goes to the likelihood of this being an offer that is going to be effective would have been legitimate. So the criticism is not of creating a priority lane or a priority approach. The criticism is to create a priority for offerers that have been referred by politically exposed persons, which is operationally relevant and breeds risks of corruption. And on that, I would also like to comment that some of the evidence in front of the inquiry puts a lot of emphasis on the perception of corruption, as if almost it was an issue of managing public reaction to what was being done. And I think that misses the point of the actual vulnerability of the PPE buy-sell to corruption the way it was created. And to me, that's a key point that needs addressing. It's not about whether suspicious journalists are going to say this thing or the other. It's about putting processes that are as robust as possible to prevent corruption in a situation where things are done quickly and probably not with the transparency and reflection time that would be available in normal times.
In the proposed alternative system that you have shared with us, where, say, a company without at least 3 years' experience is excluded from consideration, or one that is unable to provide at least 1 million items, would there then be the same need for feedback, for follow-up, that iterative process that went on within the VIP lane, or is there some other system that might obviate the need for all of that?
I think if the parameters were clear, then it wouldn't require feedback, because the government could simply say, as of today, for example, we only engage with companies with more than 3 years experience. If we don't get enough with those companies, we will come back to you. That would be obvious to anyone. And so any objective threshold would prevent the need for follow-ups. The other thing that would allow is for a much more structured response, where the specific reason why something is or is not taken forward is almost predetermined, because there is a clear threshold. When things are done in a very unstructured way, then every decision needs explaining. So even in the context of an MP chasing, it would be much easier to say the company you referred doesn't have 3 years experience, therefore it's not progressed, than having to justify why under fast-moving approaches to prioritization, that specific company is not being taken forward.
We've touched on data and its smart use in this context. Could that play a part in managing a system to consider a range of offers under great time pressure and changing demands?
It would. So I think one of the key operational problems that the PPE buy-sell had was that it had insufficient and very unstructured data. So every time they wanted to find out more about a specific offer, they had to go back to the offerer and ask for more details. They also didn't have a way of, on the click of a button, comparing different offers. This is not science fiction. In procurement that engages with large numbers of suppliers, such as framework agreements or dynamic purchasing systems, there are established approaches to collecting structured data and creating electronic catalogs, which basically would allow someone that is told, today we are really looking after visors, to simply prioritize in relation to visors, and also not any visors, but specific types of visors. I think the other problem with the data, as far as I have been able to see it, is that it was at category level. So gowns. But gowns come in all sizes. So it would also be difficult within the category of gowns to find the specific gowns we need. So I think there was a poor approach at the beginning, because there was a rush, to thinking about how detailed the information we need is going to be. And I think that maybe would have been mitigated if experts from NHS supply chain would have informed that, for example, saying, this is how we structured information for the gowns that we buy. I don't know if that happened. I haven't seen the evidence, but the indication is that that didn't happen because NHS supply chain was doing its thing and PPE buy-sell was doing a different thing. But also, once there is a review of these issues, because the PPE buy-sell is so overwhelmed, once they developed a Mendix database, fundamentally a new way of trying to structure the information, that structuring is process-based. They are concerned about, can we record when we call suppliers? Can we record when there's been a handover from the opportunities team to the technical assurance team? There is no thinking about the structuring of the data on a product line basis, which is what would have been really needed for people having to change priority quickly or comparing issues by volume, for example.
Do you want to just explain what Mendix is?
So the understanding I have is that Mendix is a low-code database platform. And what happened in this context is that the PPE buy-sell started receiving information in a very unstructured way through a SurveyMonkey. Then they created a web form that would fit into an Excel spreadsheet, but they had problems ensuring the integrity of the data. So then, on a specific weekend of March, they brought in a team from the data pool from Cabinet Office to develop a new database, and that database was coded in this Mendix language, so to speak. And that became, through a process of iteration, the data platform for the PPE buy-sell. But what is also not clear to me in the evidence I've seen is how these things were transitioned, how data in one format was then migrated into Mendix, and what the filtering functionality by line item in Mendix was. But to the extent that I've seen it, it was not particularly advanced. And I think the government's chief commercial officer has recognized in the evidence that it was something rough and ready and relatively pedestrian, put in place quickly. So I wouldn't expect it to be particularly good at filtering data.
But it could be better.
It could be much better.
And offers could be required to provide information that would feed directly into Mendix or whichever system replaced Mendix.
Yes, so the other thing that I was surprised to see in the evidence is that once Mendix is developed, there is no systematic approach to going back to every offer and saying, we are now using Mendix. This is the template you need to fill in relation to your offer if you still want it to be considered. These were still being done through specific caseworkers that were contacting the offerers. So instead of the public sector offloading the requirement of putting the data in a specific context on each of the offerers, which would be a small burden on each of them, took it upon itself to put all of the data in that context, as far as I've been able to see.
All right, Professor, I want to move you on to the ventilator challenge, but I don't want your last bullet point to be forgotten, and I don't want you to be deprived of the opportunity to say anything further, if you wanted to, on the parallel supply chain, including the VIP lane. So let's just start with that final bullet point where you make a simple observation, but an important one.
Yes.
Do you want to just share that with the inquiry, please?
So I think the observation is that once everything is counted, the volume in pounds of the contracts awarded through the VIP lane make up 50% of all of the contracts awarded through the PPE buy-sell. And I think that's stark and to me, potentially very problematic in the context of officials fundamentally downplaying the impact that the VIP lane had or seeking to justify it. I think that the fact that half of the value spent was through an unlawful route should give us time to pause and reconsider.
So it's stark for you because it's unlawful rather than because the HPL offers represented a small minority of overall offers?
So for both.
For both reasons.
So the issue that they represented a small amount is what I had raised earlier, that it was this 10-to-1 by supplier chance. But the fact that this time later, those involved don't really recognize that billions of pounds were spent unlawfully and that is a big problem, to me, speaks to a dysfunctional culture of lesson learning.
All right. Anything else you want to say on the parallel supply? No. So in that case, let's move on, if we may, to the ventilator challenge. It's box 20. It's page 131. Same document, 000 539 153. And it's fair to say you have some concerns also about this aspect of government procurement during the pandemic.
Yes.
Yeah. So once again, if you'd like to speak to box 20, please.
Yes. So ventilators were another of the items that were in high projected demand in the early stages of the pandemic. There was an insufficiency within the NHS system, so the government also set out to buy ventilators to increase capacity. They structured this through a two-prong approach. One approach was to try to buy ventilators that were already licensed for use in the UK from existing suppliers, and the Department for Health led on that effort. And then Cabinet Office created the so-called Ventilator Challenge to try to explore the possibility of adapting or developing new ventilators and prototypes. The reasons why the Ventilator Challenge was created are also important, as in with the VIP lane, I think, because I would have imagined that the second best option to buying ventilators that are licensed and produced by the manufacturer would be to obtain a license so that somebody else can manufacture the same safe-to-use ventilators, rather than trying to develop new ventilators. The evidence in front of the inquiry shows that typically it can take years to develop a new ventilator. So I am at pains to understand how an approach to emergency procurement would have been extended to the development of new prototypes that would definitely not be available in the short term, and that was also a high-risk endeavor in terms of the expenditure of public funds, because like all research and development, it's not necessarily going to be successful. So the first thing to say is that the reasons why the government has explained to the inquiry they didn't really pursue more than briefly the possibility of licenses are, to me, not fully satisfactory, because the government chief commercial officer has submitted that when they approach manufacturers asking for licenses, all but one refused. And they imagined that the reasons for that refusal would be that they were really busy trying to scale up their own production, that they would be worried about the availability of components, and that they would be worried about liability if, for example, there was injury or death as the result of an improperly manufactured licensed ventilator. But in the evidence in front of the inquiry, within the context of the Ventilator Challenge, it's clear that Cabinet Office directly engaged with the issue of supply chain for components, to the point of directly approaching producers for components. They also funded a very large number of consultants to support the technical development of new prototypes, so they could probably also have provided consultants to train on the production of licensed models. And they also provided immunities from damage, but also from intellectual property infringements to third parties. So one of the things that I would think are of interest to the inquiry is trying to understand in more detail why a government that is willing to step in to support supply chains, that is willing to engage a significant number of private consultants, and is willing to provide indemnities, would not, as a first approach, try to do that by follow-up with existing manufacturers, and would rather try to facilitate the development of new prototypes. Also because that approach immediately means that the award of those contracts was in breach of the extremely urgent procurement authorization Regulation 32, because as we said through the morning, you can only award contracts for what you immediately need. You need to be sure that you will get the supplies quicker than if you had run a competitive procedure.
Is that, Professor, why the point you make is a procurement point rather than just a commercial point?
Yes, because commercially, I don't know whether it would have been possible or not to persuade the suppliers. But from a procurement perspective, that was not a legally permissible approach to take.
All right. So what was the better approach?
So the better approach would have been to carry out, at the very least, a competitive procedure with negotiations, which would only have required the government to comply with a very quick, accelerated time period, and would have ensured that the terms and conditions that they were agreeing with those looking to develop the prototypes were market tested. And it would also have allowed the government to have a much more, from the beginning, structured disclosure of what they were doing. It could also have brought other potential innovators to the table on the basis of advertising the opportunity. By simply issuing that specific call to arms and calls with industry and creating specific teams, the government not necessarily would have guarantees that everyone that could have developed new ventilators was included, whereas a competitive procedure would have allowed those companies to come forward. I think it would also have been possible to meet all of the reasons why the government thinks they needed to engage in direct awards through that approach. So the government would have been able to pay the innovators for their participation in the competitive procedure with negotiations. They would have been able to retain ownership of intellectual property created under the contract. They would have been able to address all of the reasons why they now explain they did or they engaged in this decision for.
All right. You say at the bottom of this box that there were some aspects of the ventilator challenge that show the UK government's willingness to use it for industrial policy purposes. What do you mean by that?
So what I mean by that is that the evidence in front of this inquiry shows that at the beginning of the ventilator challenge, there was keenness from the Prime Minister and other senior ministers to have a group of homegrown companies do their effort to deal with the ventilator shortage. And I think that homegrown already indicates an engagement with UK industry that to me is not necessarily reflective of the needs. A government in dire need for ventilators would not necessarily care whether an innovator is based in the UK or based in Singapore. They would want a new ventilator available.
But surely if you have people who can manufacture here in the UK, I appreciate they have to get supplies and the equipment they need to produce the ventilator, but surely isn't it better to have it produced onshore?
I fully agree on the production onshore, but at this stage it was not about production, it was about design. So what they were trying is to get companies to either adapt ventilators that existed or come up with a new one, and that could have been done abroad, but then manufactured in the UK.
Sorry, I hadn't followed the point you made.
Apologies if I wasn't clear on that.
No, it's probably me.
But it's also not at that general level of referring to homegrown companies. But from the beginning, it is clear that some companies are involved in the ventilator challenge on grounds that don't have actually to do with their ability to develop a ventilator in a very short period of time. And it's also clear in the evidence that is in front of this inquiry that in particular in relation to Dyson, there was preferential treatment, and there was preferential treatment for political reasons, and preferential treatment that was not only impermissible under the procurement rules, but it was more generally impermissible in matters dealing with public interest, because there were key decision makers considering what Dyson wanted or what Dyson would get out of an award of a direct contract, rather than what the public sector would get from Dyson under that contract.
All right, well, I think we can leave it there because we're going to be hearing a little bit more about that tomorrow. Let's just turn to the last bullet in this box, if we may, Professor.
Yeah,
you draw the threads together.
So the last bullet comes to say, by having senior ministers instruct civil servants to award a contract to a company, even if it's a contingency contract, on the basis of the interest of that company or how that company is going to be able to market its products elsewhere, is impermissible. It's impermissible within the procurement rules. And here, it's no excuse to say, this was a direct award, and therefore most of the procurement rules don't apply, because the decision itself to engage with direct awards was not in line with the rules. So the fact that this didn't happen within the context of a competitive procedure, for example, doesn't detract from the fact that that instruction to award a contract was just impermissible.
Understood. Thank you, Professor. We've dealt now with procurement pre-pandemic. We've dealt with procurement during the pandemic. I want to turn relatively briefly now to that third phase, that third period of time which you address in your expert report, the post-pandemic period. And it would be helpful if we could have summary box 22 brought up. It's on page 140. Obviously, same inquiry document, 000539-153. And you start with a reference to the Boardman review. Just for those who are not familiar with it and its consequences, if you'd like to introduce this box by explaining briefly those matters.
Yes. So at a later stage of the pandemic, the government itself asked Sir Nigel Boardman to engage with two reviews of how procurement had taken place, and the one that this refers to is the second review. And in that second review, there were findings of operational challenges and difficulties in implementing the reaction to the pandemic from a procurement perspective, and there was a long list of recommendations made. In my view, those recommendations are adequate. I think there are also some more recommendations that could have been made on the basis of the analysis in the Boardman review, for example, about IT systems. But the position at this moment is that the government has formally accepted all recommendations, and the evidence in front of the inquiry is that the recommendations have been implemented. But all accounts of the implementation of those recommendations on revising how NHS supply chain operates, or revising issues of staffing, or revising issues of data, are process-based accounts that simply say, on this date, this committee said this. On that date, we considered the recommendation was implemented. But there is no detail whatsoever of what specific measures were adopted, what specific changes have been implemented, which means that there's no external possibility by civil society or this inquiry, unless it's given more evidence, to make a judgment on whether any of the specific recommendations have been sufficiently or properly implemented. And to me, that basically means we need a more open approach to explaining what was changed. So if Crown Commercial Service and the rest of the government commercial function was not working in a particularly joined-up way, like the Boardman review fleshed out, what's been done to make sure that it works in a more joined-up way, rather than simply saying, we have made them work in a more joined-up way. We need more detail to understand that. And it is important because probably this inquiry will want to make recommendations along the same lines of what the Boardman review said, and it would not be good enough for the response to be, we already implemented this in the context of Boardman. And that's why we need more detail.
Does the enactment of the Procurement Act 2023, just last week, have any bearing on this at all?
So it has a bearing in that at the time of the Boardman review, there was a proposal for new legislation, but there was no bill at the time. There was only a process of reforming. And there was an expectation or a hope in the Boardman review that the Procurement Act would fix some of the issues that were identified in that analysis. In my view, that's not been the case. So in my view, the Procurement Act has not meaningfully changed any of the issues that arose from systematic non-compliance with requirements for emergency procurement, and the new regime doesn't create adequate enforceable safeguards. So in that regard, I think that's the bearing it has, that there was an expectation that some of the issues identified in the report would carry through to legislation. In my view, that's not happened.
All right, thank you for that. You make a particular point. Yes, that's fine. Thank you for that. You, if I may say so, are a valuable source of international comparisons. You deal with a comparison of approaches in the next section of your report. You look at it both across the devolved administrations and then internationally. I wonder if you could pick up those points, starting with the devolved administrations, offer your comments, your reflections on that comparison to be made, and then move on to the international comparisons, please.
Yes, so the short of the comparison is that the general approach to reacting to the pandemic was very comparable in the UK and other jurisdictions internationally, but also within the four nations of the UK, except for the VIP lane. So the VIP lane is clearly an outlier. There was no equivalent in the devolved administrations, as far as I could see. There is no equivalent in any international jurisdiction, as far as I've been able to assess. So that's the main difference. The other issue is that in other jurisdictions that had a more restrictive approach to emergency procurement, for example, by enacting requirements of minimum number of offers, like was the case in Italy or in Romania, at the beginning of the pandemic, those requirements were overridden or suspended.
Minimum number of offers, how does that work?
So that would work in those jurisdictions. Before you can engage in a direct award, you need to ask for offers from a minimum number of potential suppliers.
I see.
So rather than choosing supplier one and contracting, you need to approach suppliers 1, 2, and 3, and then on the basis of those 3 offers, provide a contract. That was suspended or withdrawn because it was not practicable. So this is to say that the UK's flexible, permissive approach to direct awards was in line with what happened in other jurisdictions, either because of prior legislation or changes brought in because of the pandemic.
So you refer to the Germany's take it or leave it market engagement. Do you want to just explain how that worked?
Yes. So in Germany, at the outset of the pandemic, the relevant authorities published a set of contractual conditions for different products and basically said anyone that wants to provide these specific products in this specific condition is going to get a contract. So this is an approach where the contracting authorities go to the market with their maximum price, for example, or maximum tolerance with a specific technical requirement, and whoever can meet it comes forward. There's no need for negotiation. There's no need for triaging. And although it's been commented that after the fact, that approach was not necessarily fully successful because some of the contracts were also problematic, what I say in the report is that that is a completely different approach to the market. Instead of completely unstructuredly going to the market and seeing what comes in, which can overwhelm a system, going out with a specific set of conditions both prevents corruption and maladministration in the sense that the conditions are set, they are not open to negotiation, but also very much reduces the bureaucratic task in that the offers will or will not match the requirements. That's it. So my point there is that that would have been a more procurement-informed and likely to be successful approach to go to market saying we need these specific types of PPE, this is the price we're ready to pay, or even if price was negotiable, this is a ceiling of price or something like that, than trying to just try to see what the market can offer.
All right. You make the observation in your section on the devolved administrations that there was no equivalent of the high priority lane in Wales, Scotland or Northern Ireland. You make a similar observation in relation to your international comparison, that as far as you know, there is no equivalent of the high priority lane abroad. If you are able to comment, then please do. To what do you attribute the uniqueness of the high priority lane, the VIP lane, within England?
So I think, in my opinion, it comes from the approach to deference to ministers and MPs that is embedded in the way the English civil service operates. There is usually a level of ministerial access to activities of the civil service that I don't think exists in other jurisdictions, not only in procurement, but generally. So because of the specific way in which, for example, constituency work is done, MPs sometimes legitimately follow up with civil service. There's no hard and fast division between what is appropriate and what is inappropriate engagement. It's a much more loose context than in other jurisdictions. And I think that tradition and approach to ministerial deference, in this case, created a very significant problem. Because I think where you have more ministerial involvement, it's more difficult to draw the line of what is allowable or not for a politically exposed person to do. And I think that the same way, for example, we would not think it permissible on the basis of convention for an MP to be asking Ofcom what's happening with his license, for example. The same thing should happen in procurement. But for some reason, that sort of innate impermissibility of the level of engagement didn't work here.
But doesn't that, isn't there a similar level of engagement between ministers and officials in the devolved nations, for example, in Scotland?
So I don't know if that happens as a matter of general course, but on the evidence I've seen, there was no involvement of ministers in the way offers were triaged or...
No, but not in, sorry, I'm not talking,
right.
I'm just talking about generally. I thought you were saying that one of the reasons that the VIP lane may have become possible is because there's a close engagement between ministers and officials. But I'm asking whether that principle doesn't also apply to Scotland and possibly Wales. I can't remember about Northern Ireland because they act in, a bit more in silos. But I'm suspecting that the level of engagement applies throughout the UK. And therefore, why is it that only England gets the VIP lane?
So I think, without disagreeing and with all respect, it's not actually true that only England gets the VIP lane, in the sense that the VIP lane was for the 4 nations. So I think in this specific case, what happened was that the aggregate buying of PPE at that scale was carried out in England, but it was basically for everyone.
Oh, I see. Thank you.
So I think that could have been a distinctive factor.
All right. I think finally now, Professor, you have offered reflections, possible recommendations as we've gone along, but your box 26, your final box, which is at page 161, INQ 000539-153, which fits onto a single page, is where you address the current state and the future of emergency procurement. Some of this we have dealt with already, but would you kindly just draw out anything that remains to be said, particularly in relation to the third from last bullet, where you have included a number of the recommendations that feature in this section of your report at paragraph 393.
Yes, but before we get to that one, if I may, I would like to talk about the 4th bullet from the top, which I think is a fundamental criticism of the changes brought forward by the Procurement Act 23, which is to say the Procurement Act has not changed the mechanisms for enforcement of procurement law in the applicable jurisdictions. And the same way that under the PCR, we were expecting contracting authorities to publish a transparency notice, and if they didn't, there were limited routes to challenge that decision. The Procurement Act 23 very much continues in the same way. And there may be some discussion brought forward to the inquiry on the creation, for example, of the procurement review unit or other mechanisms of oversight. In my view, they will not significantly make a difference. We will still have the fundamental problem that if a direct award is given without complying with transparency obligations, it's very hard to know about it. It's very hard to do anything about it. So that's something I would like to highlight, that by not changing the review or remedies regime, the Procurement Act has not made a difference in the enforceability of the requirements. And what my report has shown is the requirements were there, they were just not complied with. So we could have a repeat with the requirements being in the Procurement Act, but there not being a mechanism to enforce them.
What sort of mechanism did you imagine might have provided the teeth to the new Act that presumably you regard as now missing?
Yes, so an administrative review body, which was included as a possibility in the initial December 2020 Transforming Public Procurement Green Paper, would have been, in my view, the best way forward. So having a review body that is established and that could have, if necessary, standby specific powers for situations of systemic emergency would be the best way to go. And I'm not the only one in thinking that. There's, I think, a consensus in the practitioner community that there was a very big missed opportunity in this ITER to create in the Procurement Act in not creating an administrative-based system of review of procurement decisions.
Thank you, Professor. You've set out a set of recommendations at 393. They feature in this box.
Yes.
Would you just touch on those that have not already been addressed?
Yes, so that's the third bullet from the bottom that you were pointing me to earlier. And I think that if there is to be a meaningful change in the way rules are going to be followed, but also in how emergency procurement will be carried out better in the future, there's a quite long list of complicated interventions that need to take place. I think the first thing is that we still don't have a fully integrated electronic procurement system that applies across the UK, and I think that needs addressing as soon as possible. There are models like the PEPAL model, and I didn't go as far as recommending a specific approach, but I think what would be required is for the government to have a very structured approach to ensuring that there is e-procurement fully rolled out, it's fully interoperable, and it feeds into data. And that will require funding and a dedicated change management plan way beyond what's been put in place, for example, for the Procurement Act. I think there's also significant investment that needs to be made in professionalization and capacity building. And I think the Procurement Act, for example, has shown that the approach to training in the transition from these derived EU rules to the new rules in the UK, which are supposed to carry a significant cultural shift, has basically meant that the standard civil servant has been given 10 hours of self-directed e-learning as training. I just think that sort of scale of training and professionalization is not going to improve things significantly. I think we need a lot more done in that regard. I think we need more coordination across procuring organizations. For example, I would like to know that there is a set coordination mechanism between the centralized healthcare organization in each of the nations so that we don't have to put those systems in place when we need them. And more generally, there should be clear standby or break glass arrangements to ramp up procurement capacity. So if at some point we, again, face the need to buy much more than we were buying of something, who are we drawing from? Can we have those people pre-identified? Can we have them forewarned that they may be called? Can we stress test those systems as we go? I think we would also need to have pre-established spend control and due diligence mechanisms in place, because I think what the evidence in front of this inquiry shows is that this was a movable feast. Thresholds were raised. Delegated authority was significantly increased. The conditions were maybe not always clearly set or clearly understood or clearly adhered to. And I think we need a significant, more structured, predefined approach to this issue. And I think we need to have a significant improvement in procurement data. This has come across many times this morning, but even with the Procurement Act's central digital platform, as of today, there's no search. And as of today, there's no dashboard. So it could be that the data is collected, but nobody can access it, nobody can use it in a meaningful way. And I think we need a lot more to do in terms of making sure that the data is open, that data can be exported and used by different reusers in ways that can just not be possible today. In terms of reuse, I think it's also important to think about looking back at data. So I think there was some effort to try to identify who has historically been providing PPE, if they are not current providers, but that was done on the basis of very patchy, sometimes outdated information. I think it would make sense to recommend the creation of dynamic purchasing systems, or now called dynamic markets, for items that are likely to be needed, rather than just-in-time contracts, so that when the need arises, at the click of a button, all those registered in the dynamic market can get a notice to say, we think we need lots of PPE. Can you please tell us what is your position now? Can you provide? And we have that preset. I think it would be a low-cost, very significant intervention. And I think this is more difficult, but I think we need structured mechanisms of risk mitigation. And by that, what I mean is that we need to have sort of suspended but susceptible of deployment mechanisms to look at those risks that we are taking. And that has to do with decision-making, for example. It cannot be that all of a sudden we're trying to come up with new ways of identifying risk or mitigate for it. We should have a structured approach to doing that. And we should have people trained to do that. And, for example, using standard contract clauses could go some way to that, having a lot more detailed and prescriptive standard contract clauses for emergency contracts, for example, than we had at the beginning of the pandemic. And the final one, which is probably the most difficult one, but probably a very important one, is that I think there should be a culture of integrity and commitment to zero tolerance of conflicts of interest in procurement. If something potentially looks like a conflict of interest, it needs to be acted on, rather than the sort of relatively high threshold I think we operate under, or we definitely operated under during the pandemic.
Professor, thank you. Subject to any further questions from the chair.
I've one more.
Yep.
Going back to the Boardman review, sorry to take you back, Professor. I found online government response to the Boardman review dated the 7th of May 2021.
Yes.
I think that was when they said that majority of his recommendations had already been implemented, but in any event they were accepting them all, and they'd keep the Public Accounts Committee updated.
Yes, that's correct.
Did anything happen? Did you hear anything after that?
So I haven't heard anything. That was also a piece of evidence I couldn't rely on because of parliamentary privilege. But that is the sort of explanation to say we have implemented them. But I haven't seen any follow-up reports or more detailed accounts. It could be that the PAC has them, but they've not been published.
Thank you.
In that case, my lady, Professor, thank you for your written and now oral evidence. That concludes both of them. Thank you very much.
I'm really grateful to you, Professor, all the help you've given. I mean, I appreciate that it's so much your specialty that you may have quite enjoyed getting all this together, but it's been extremely helpful, and I'm very grateful to you for your written report and, of course, your evidence this morning. Thank you very much indeed.
Thank you.
And safe journey back to Bristol. Is that where you're going?
Yes, that's right. Thank you.
Very well. I shall return at 2. All rise.